Okay. She's almost like
Almost of the class. Yes, it's all English.
I am kind of expecting that. It depends on the deal, but I think my comments are more like, I mean, I haven't really drafted like the sentences. I'm gonna improvise something, but I think my comments will be somewhat like questions to you. So maybe if you can react to my comments, that would be very helpful. Really?
It's my first time.
Oh yeah. This kind of like the theater
Oh, my first time.
Really? So you're PhD. You haven't finished your PhD thesis. Wow. So okay, I'll try. Congratulations, your proposal has been accepted. That's why you came here.
Yeah, that's Thomas. Yeah, that's his notes. Yeah.
Very top conference in information.
Exactly. Yeah, I think so. It's really your proposals must have been very good. It's very competitive. I know like a senior professor from Japan, he made the proposal, but he didn't get it because of his
You tell us when we can start.
Well, good afternoon. I very much would like to welcome you to our panel on anti-coercion, panel 21. I welcome you in the room. I welcome also colleagues online. It's a pleasure to introduce the members of the panel. Tianqian Ni. She is a WTO Chongyuan Institution for Economic Research Assistant Research Fellow in Taiwan. Then Professor Lidiana Vukovic is a professor at the University of British Columbia. Professor Yuka Fukuoka from Waseda University in Japan, and Dr. Lothar Ehring, senior expert of DG Trade in Brussels here. Throughout history, states have always used trade measures for political ends to address essentially a political problem rather than a commercial or trade problem, but using trade tools to this effect here. And I just recall again the book by Andreas Löwenfeld, which was published in 1983, depicting the long history of these kind of measures. But I think in recent years, we have seen an enhanced recourse to such measures for political ends. And countries started to reflect how to react to these kind of measures. And currently we have legislation in the EU being developed, and I'm very glad that Lothar, who is one of the architects of this, these measures, is with us, and as well and in the United States. But of course, the debate goes much broader than simply the response, but actually to what extent these measures taken for political ends are in line with international law. We have two papers which are presented in this session, and we start off with these two papers. Each of the presenter has 7 minutes, and then we have 2 comments on the papers. So that gets us done within half an hour for the paper presentation. And then we move into the discussion. And the first question we would then want to discuss, and I would really like to include you in the room on all these sessions, on these issues directly. It's then to what extent are these measures compatible with public international law? The question about the use of force and the threat of use of force, to what extent can that still be distinguished from economic measures as we traditionally do? And then to what extent are these measures compatible with WTO law? On the one hand, the measures imposed, but on the other hand, also the countermeasures. And the question I'm personally then most interested in is, can we develop collective action reactions to these kind of things, or do we have to leave it just with the unilateral approach we normally apply today in the multilateral system here? So we would start off with the paper from Ting-Chen Yi. It's a more general paper, and I give you the floor.
Thank you, Professor. Okay, so thank you all the professors here. I'm Ting-Chen Yi. I'm very grateful to be part of part of this panel with all the distinguished professors here. I'm a PhD student from NYCU based in Taiwan, but I'm also working as a research associate at Taiwan WNRT Center at SEER. And so because of my background, I would like to share some trace data related to the case I'm going to introduce you later. So I think before we talk about anti-coercion, we should first understand. I know. Yeah, sure. Thank you. So I better stand here. I think before we talk about anti-coercion, we should first understand what is economic coercion. And I believe that addressing this problem is more necessary than now than before because of its impact on multilateral trading system. And I would like to give you an example in Taiwan recently is facing to explain what is happening now. So most of the time, China exerts economic pressure by refusing to import agricultural products under the disguise of SPS measures, right? So if anyone still recalls last year when Nancy Pelosi visited Taiwan in August, before and after, actually China has suspended the importation of more than 1,000 of agricultural products into Taiwan, citing the reasons such as excessive pesticide residues in citrus fruits and detection of COVID-19 on the packaging of seafood. So, but this year, China has actually created a new form of economic coercion that is called this trade barrier investigation. So on April 12th, China announced this investigation against Taiwan because Taiwan has adopted restrictive measures targeting more than 2,400 items from China, which covers agriculture, textiles, and mineral sectors. And so although this investigation is supposed to be ending in October, this year, October 12th, but China government also stated that under special circumstances, this investigation could be extended to the next year, January 12th. So in fact, for the last 2 to 3 decades, due to some historical reasons, Taiwan has actually restricted 2,455 items imports from China. And this trade dynamic has made Taiwan actually enjoy a trade surplus of around $156.5 billion. So people would be guessing if China wants full market access from Taiwan. However, when we look at this graph, the restricted list of products has only very slight trade value between the two countries. And only over the past 5 years, actually, the MW0 products only made up around 3 to 4% of Taiwan's total exports to China, which amounts to approximately $4 billion. So in terms of the overall economic impact, actually, the impact is not really significant. So then why China still wants to do this, adopting these measures against Taiwan? I think the sure thing is that China does not want full market access because our market is too small. But we can see that although China has threatened us to impose economic costs on Taiwan with two actions. First is this trade barrier investigation, and followed by taking the punitive tariff symmetrically regarding the same list of the items. However, the actual economic costs are not what China is seeking. Rather, these economic pressures stem from underlying political intentions, especially when we know that the date of January 13, 2024 is actually the date of Taiwan's presidential elections. So by extending 3 months investigation period to January 12 next year, China thinks it can make influence on our elections. And this is one of the common tactics of economic coercion, actually. So by this investigation, it can create a societal atmosphere telling Taiwanese people that to face the reality that China used to give us a favorable treatment in the past, so we can't get it for free anymore unless we are willing to talk about the issue of cross-strait unification. So on the other hand, China also wants to showcase domestically that it has the upper hand in building the cross-strait relationship. So in my paper, I've also investigated some possible counter strategies against economic coercion. And these strategies can actually be broadly summarized into two aspects. One is direct response, that could involve measures such as mirroring the coercive actions or just do public announcements in the diplomatic occasions. And the other kind of counter strategies is indirect response. So this might focus on enhancing the supply, building a resilient supply chain, or receiving economic assistance from other third countries. So the key point of this kind of indirect response is to mitigate the negative impact from the coercion without provoking a coercive state. In the final part of my paper, I actually chose anti-coercion law as case study among other available anti-coercion tools. While both the EU and the US have introduced their own version of anti-coercion laws, I think the proposed responses are somewhat different. And this difference also indicates varying levels of the consistency with the WTO. So time is limited. I'll just quickly sum up the results of my research so far. First is that economic coercion has become a favorable tool because it can easily bypass military conflicts and targeting vulnerable industries in small countries. And I think the introduction of anti-coercion laws is understandable because economic coercion often adopted through informal channels, and it is hard to define the exact form and the exact scale. So it could be a big challenge for the affected state to identify the specific measure and to resort to the WTO. So the third is that anti-coercion law is rapid and efficient. I recognize that, but its legality remains unsettled, and the ambiguity might arise when it is adopted without legitimate justification. So I think that maybe prior consultation with the coerced state or the provision of economic relief to the coerced state can reduce further retaliation and escalation of trade confrontation. Thank you.
Thank you very much for being wonderfully in time. And I'm pleased to give you the floor for the case study on Lithuania.
Okay, I don't have any slides. I'll try to be really short and precise. So in my paper, I actually looked into this case, the dispute between Lithuania and China that later spilled over into being a dispute between EU and China in WTO. And I looked into the EU response to Chinese restrictive measures imposed on Lithuania in the context of the EU attempt to develop a long-term strategy to deal with China and to enhance its open strategic autonomy, meaning to remain open for trade and investment while building resilience and self-reliance and being able to respond in much more assertive way to unfair behavior of states, because that's what really economic coercion is. It is unfair behavior. Really what the EU seem to be trying to do is to survive the new geopolitical reality. And that reality is that from June 2022, the EU has become the largest target of China's coercive measures. And in short, Lithuania got targeted by China's restrictive measures because in 2021, it allowed opening a non-diplomatic office of Taiwan in Vilnius, but under the name Taiwan, not Chinese Taipei. So these economic coercion measures were utilized to basically force Lithuania to change its foreign policy course, which has been pro-Taiwan oriented, since Lithuania supported, for example, Taiwan's participating in the work of WHO. It also was very critical of China's human rights regime and treatment of ethnic minorities. So interestingly, the EU started turning its attention to the impact of China on the functioning of the internal market and its member states, sometimes around 2019, when the joint communication entitled The Strategic Outlook on EU-China relation was published. And I emphasize that because that, to me, is the beginning of thinking about this as a long haul strategy and comprehensive strategy, because it has to address three dimensions of the relationship between EU and China, and that is partnership, competition, and systemic rivalry. So this case is illustrative for a number of reasons. First, it's a standard circumstance in which economic coercion thrives, asymmetric interdependence and trade imbalance. I mean, Lithuania is really not a big trading partner for China. It's only 1% of Lithuanians' trade that even goes to China. It has trade deficits with China, but who doesn't? You know, even though it has bilateral investment treaty with China, even though it was the part of 16+1 forum, it never received major investments from China. It's something like 40th foreign investor in Lithuania. So really not a big deal in terms of, you know, their trade. But this is still the first case that China imposed such harsh primary coercive measure on an EU member. So very disproportionate considering the amount of trade, and very harsh because simply, you know, one day nobody could actually register through the customs administrative website, and it was total embargo. And Chinese responded that it was just a glitch. Well, after a week, the glitch was so to some extent resolved, but still there were restrictions following all the time. So anyways, it is also the first case that China threatened to impose secondary coercive measures against other member states' companies that use Lithuanian parts for goods that they export to China. And this is the first case that the EU brought to the WTO in relation to alleged economic coercion against one of the member states. Of course, China previously threatened and imposed some restrictions on other countries like Sweden and Czech Republic, but EU never got involved at that level. And what's also interesting is that both Lithuania and EU tried first bilaterally to resolve this through consultations with China. It didn't work. So eventually it opened up, you know, the space for a dispute to go to the WTO, which European Union did, requesting first in January 2022 consultations. Then in December 2022, requested the establishment of panel, which actually happened in late January 2023. And the panel was composed in April 2023, but we don't have the report on it. Now, interestingly, the dispute was unfolding when the EU actually still had the anti-coercion instrument regulation in the pipeline. And in my view, even if the legislation was in force at the time when this dispute has, you know, started, I think that the EU would have chosen the same path, at least what it says in the proposal for the legislation, that it will go to the WTO rather than trying to use the avenue that the ASCI is proposing, and that is that, to challenge the case as being really the violation of the non-interference principle and customary international law, and it wouldn't really impose sanctions. So if I am on time, I just want to say one more thing. Do I have-
Sure.
Okay.
Yeah, another minute.
What's really interesting is that after Chinese embargo, a number of Lithuanian companies lobbied the government to change, its path and to ask Taiwan to change the name of the office. And also German companies operating in Lithuania and also, having interest in China lobbied the government to do the same. And I think there was a moment of regret even for the Lithuanian president, because in one point he said, well, maybe that was a mistake to, allow this office to happen. And Lithuania really suffered and struggled to recover the losses. And I have to say that, they first applied to the European Commission, and they sought to approval of the scheme to provide 130 million euros in the form of loans to Lithuanian companies affected by these restrictive measures. And they also asked to reallocate the part of its 2.2 billion COVID-19 recovery grant from the Commission. I don't know how that goes. Maybe you can fill in whether they got any money of that. But 130 companies really couldn't export at all to China. And it wasn't really easy for all of them to quickly turn around and find new markets. So that's the real impact on small economies, right? So thank you.
Well, thank you very much. We had a wonderful insight into the situation in Taiwan and with Lithuania and the EU. I think there were also other countries targeted, particularly Australia went through a cycle. Are you aware of any other countries?
Canada.
Canada as well. Okay,
Yeah.
so it's a pattern here we see. I would propose now that Jukka, could you comment 5 minutes on the paper, maybe also raise questions you have,
Yes.
and then Lothar would do the same for your paper.
Thank you. And thank you, Ms. Ney, for your very interesting intervention. And I also read your excellent paper. It's an excellent interdisciplinary study of anti-coercion instruments. And I think you're quite right that we have to analyze this issue from not just from a legal perspective, but from also political perspective. But since I am an international professor, let me make some comments from an international law perspective. And I think I'm going to make 3 comments, but many of my comments are related to what Professor Cotier raised for discussion. So maybe I'll just give an outline of my observations and leave more deeper discussions later. So my first comment is about the definition of economic coercion. And in your paper, you defined, you raised several definitions of economic coercion, but one of the definitions you gave is that it's a situation where one country threatens or imposes economic costs on another country to influence or change its foreign policy. And I think that probably in almost every definition of economic coercion, there's an element of intent or objective. There is an intent of coercing country to change the foreign policy of another state. And my question is, and that intent, the element of intent involves subjectivity or maybe arbitrariness. So my question would be how to define or how to determine the existence of this intent and how to make sure that the determination is not arbitrary. And also maybe I have a question about the necessity of defining an action as coercive action. For example, maybe it's just the lack of my understanding, but you raised an issue of trade barriers investigation against Taiwan. And this trade barrier investigation maybe in itself a violation of WTO law, even without it may be a coercion or it may not be a coercion, but anyway, it has a trade restrictive impact. And for that reason, it may be a violation of WTO law. So I'm wondering, why do we have to define something as a coercive action? So my first observation is about the definition of economic coercion. And the second question is really like a big picture question that I don't have an answer to. It's about the relationship between the WTO law and international law, or to be more precise, it's about where WTO law is situated in the realm of international law. And in your paper, you said that, or maybe this may be in the EU position, if something falls outside WTO, it's a matter of customary international law, and WTO law may not apply. But to me, I think customary international law and WTO law can apply to the same issue. So one thing might be what, for example, an anti-coercive instrument may be justified as countermeasure under public international law. But that does not mean that the measure, countermeasure, may be in violation of WTO law. So how do we sort of reconcile these different areas of international law? So that's my second very big question. The third is really general observation. And I totally agree with you about the implications for the multilateral trading system. And to me, an anti-coercive instrument is like a painkiller. It's very, as you said, it's a rapid and effective solution. Maybe not be a solution, but it's a remedy to it's a rapid remedy to a situation. But it has side effects. So maybe we have to think about longer term, softer, like a yoga type solution to the situation. So that's my observation.
Thank you very much. You raised very interesting questions also about the relationship between general public international law and WTO law. I don't know, we'll take up these questions right away, but is there anything you would just like to quickly reply to the comment? You don't have to, but in case you wish.
I want to leave my answers later.
Okay, you do that later. So can I give you the floor, Wolfhard, for commenting Juliana's paper?
Yes, you can. Thank you. You don't have to, because I don't really have anything to comment, nothing much on what was said. But I will nevertheless try to contribute something useful. I also have 5 minutes.
Yeah.
Coercion. So first of all, what is coercion? Coercion itself is, of course, broader potentially than economic measures. Recent example is before the February invasion, there was a military buildup outside of Ukraine, on the Russian side of the border, and Ukraine was being coerced by Russia. Yeah, the demand was regime change, denazification, and more. Yeah, those were demands. That was an attempt, supported by the threat of the use of force, military buildup. So it was a breach, of course, already on the ban on the use of force or threat of the use of force. But it was also coercion because, internal regime that was, of course, an internal Ukrainian affair, and the Russian government tried to interfere with it. So it satisfies the conditions of the general international law, breach of intervention or interference in internal affairs of another state. But it was military coercion. It was not economic coercion. I glossed over now that there were also economic measures in play. But that coercion was not economic coercion. And today, the international debate about coercion is about economic coercion. And those measures, whereas what I just mentioned, that belongs in the United Nations. There are rules on this. They are pretty clear. And the coercion aspect is not important. Why? Because we have the prohibition, use cogents, on the use of force and the threat of the use of force. The only thing that is debatable is whether that prohibition exists for 100 years or only for 75 years, but it is completely established and uncontroversial. So we are speaking here usefully about below the threshold of force or threat of force. That is then also an area relevant to the WTO because the other one isn't. And so the first thing I'll say is coercion as a breach of general international law. It is again the same norm, so I will not repeat it. The prohibition on intervention, interference in the internal or external affairs of another state, that is prohibited, has always been prohibited well before the use of force was prohibited in international law. And so the only question is what means of intervention, interference, coercion. The ICJ in the Nicaragua case said, used this concept of coercion, and then said one obvious form of coercion is the use of force. But that brings us back to this other area that's not useful for us. So, and below the threshold of use or threat of force, we are indeed already in the controversial zone and general international law. The ICJ in the Nicaragua case said nothing useful on this. I know it dealt with the trade embargo. It's a very long decision with many claims, and this one did not receive attention. Nevertheless, the Nicaragua judgment is all the time used and quoted, and of course one has to deal with it. But this is one ruling, yeah, in 100 years. This is just like there were one panel ruling in the WTO, or panel plus appellate body if you really want. That does not close the matter. That does not exhaust the law on this issue. I'm telling you, although there are people who say the opposite, there are people who say there is no ban on coercion, no ban on intervention, interference, if it is not through military means. But I say that prohibition does exist. It covers more than just the use of force. And economic measures, restrictions, if they have a sufficient intensity, indeed can qualify. So then we have a breach of general international law, which you know means customary law. This is not codified anywhere. We have the Friendly Relations Declaration of the United Nations. We have other declarations which were adopted by majority and abstentions or countervotes. They are not considered customary as the Friendly Relations Declaration is, but all this does not really tell you anything more than what is anyway established. But so we have this breach. It's a bit controversial, but we think we are on the right side of this debate. Can these measures also breach a trade agreement? WTO, FTA, FCN agreements? Yes, of course. Yeah, I will not get into details, SPS, anti-dumping, Article 11 GATT. And what does that mean? Does that mean that Article 23 of the DSU applies, that it is not allowed to do anything else about this than starting a WTO dispute? That's what many people think, but that is wrong for a very simple reason, because 23 applies to the enforcement of WTO rights when a member is seeking the redress of a violation, yes, of the WTO agreement, not when a member seeks the redress of the violation of the general principle of sovereign equality, part of which is the non-intervention principle. So that's not covered by Article 23, and hence the exclusivity of the dispute settlement system of the WTO does not apply. People have other views and say, no, 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 when it is also WTO, then that takes priority. I tell those people, take something much simpler that you're all familiar with, that is the parallel breach of the WTO agreement and an FTA. Every FTA has a national treatment obligation. So if the national treatment obligation of the free trade agreement is being enforced in the bilateral dispute settlement system, is that a breach of Article 23 of the GSU? Nobody has ever argued this. I would recommend that one to scholars, because that's much more interesting, given that it is impossible to seek the redress of a national treatment violation under an FTA without simultaneously seeking the redress of the WTO national treatment obligation, because it's the same obligation. It's usually even worded the same way, or a reference to Article 3 of the GATT. The non-interference enforcement and the national treatment or Article 11 enforcement, those are different obligations. They just happen to exist simultaneously. So we have no problem with the WTO, but here comes immediately the next problem, and that is when we speak of reactions. If they take the form of a countermeasure, and this countermeasure takes the form also of a departure from the WTO agreement, then we get into this known territory of can you invoke countermeasure as a justification for departure of your WTO obligations? And I'm telling you, yes, because that is a standard, also customary international right to enforce your rights, not WTO rights, Article 23 DSU, that you can't do through a countermeasure, only via the DSU. But non-WTO law, nothing in the WTO agreement, nothing in any other agreement, by the way, ever says that it is not allowed to depart from the obligations under that treaty for the purpose of enforcing international rights by way of countermeasure. But this is something that the WTO as a system, the membership, the adjudicators still have to warm up to, because this has so far not been established. Many disputed this so far, but maybe later I can give you other examples to show why this is the inevitable conclusion. Final remark, of course, I know that the WTO has an exclusively applicable special regime of enforcement, and therefore the standard rules on state responsibility don't apply. But that again applies only to the enforcement of WTO rights. The WTO has its own special regime for the enforcement of WTO rights. That's the whole DSU. And that, of course, does not apply to what you do by countermeasure, which serves the purpose of enforcing a non-WTO international right. That's why there is no problem.
Okay. So should we stop here? I don't know. Well, you anticipated some of the issues we want to take up now systematically, but would you like to respond briefly? And particularly what I would like to invite you to be a bit more specific in defining the countermeasures which are contemplated by the EU and also by the United States, so that we know what we're talking about.
So yeah, I'd just like to add something to what was said, because you know, I think that's this interpretation of the, you know, kind of a interaction between the EU law and EU regulation with public international law and with the WTO is something that Commission has elaborated really in all of its you know, assessments reports, and also in the proposal as well. But I think that, yeah, there would be scholars who would argue that this is really a tricky area, and that perhaps, you know, it is that the countermeasures that the EU would apply, and the EU, I just want to be sure that, you know, we all understand, the EU doesn't really say that it would automatically apply the countermeasure when they make an assessment that the behavior of another country or third country, as they say, would qualify as economic coercion. On the contrary, it is really the last resort. I mean, all through the regulation, you have the process of non-intervention first, where the EU would try to really engage with that country, with other country, with international organizations, and try to really kind of avoid eye for an eye kind of a you know, interaction and retaliation. That's what the countermeasures really end up being, right? So that's the first thing. And then, you know, the second thing is that there is this idea that those countermeasures should actually not be arbitrary, but really proportionate to the harm and to the intensity of those measures that, you know, coercive measures that have actually triggered the reaction of the European Union. But I also want to just say one thing, that, you know, I came across writings where, you know, the scholars of, you know, public international law and the WTO would say would indicate that potentially, even, you know, in the text of this regulation, you see that the Commission is open to the idea that others would challenge the countermeasures before WTO. And it says actually in, I think, Article 10, that, yeah, if there is a challenge in the WTO, and if there is a, of course, you know, adjudication, that they would terminate the measure. So there is this recognition that maybe this is a gray area, that it's not so clear cut. And even if it isn't, it doesn't really stop, you know, the third country to challenge it before WTO. Now, what I want to ask, would it be possible to maybe imagine that the EU can then use kind of a justification for the measure, again, dig into the WTO rules and to say, oh, maybe there is a national security exception that we can invoke here. Or I know somebody says even maybe public morale, but I think that that's stretch. I would rather say maybe, you know, national security. And that would depend how you really define what a, you know, that really is.
Before we go into this, I just really like to clarify about the remedies.
Okay.
I read that in the United States, it's contemplated that companies may be compensated for losses. Is that also the case in the EU, that the company, the affected, could actually get compensation? The Lithuanian companies and those who lost due to these measures, they would be able to claim compensation.
No, it is not.
It's not, but in the US they could. That's the difference, is it? What is
That's
being
the bill,
discussed?
in the US.
The
that's
bill, yes, okay.
I forgot the statistics, but when I was in the United States, I learned the percentage of bills that don't become laws. I don't know.
Okay, so it's not yet secure. Okay,
somewhere-
so I think we had a very good start. I'd like to ask whether there's any questions relating to the notion and the measures and what we've discussed so far. We go now more systematically into compatibility with international law and WTO law. Any questions or comments from your side?
Otherwise, I can also briefly react, or maybe also the others want to react to what they heard.
We'll take
Or
it step by
you-
step. That's my plan. Yeah.
Okay.
So I had just a question for Ting Chen.
I think you need to speak into the mic here. Can you pass it then? Okay.
Kai Carmody, University of Western Ontario. So Ting Chen, I just was curious as to, in this situation that Taiwan is facing, whether it has contemplated the possibility of a panel at the WTO, given that both Taiwan and China are WTO members, and possibly, you know, seeking some sort of recourse, either violation or non-violation, if only to, well, you know, paper the file, as it were, so that there's a record of this that's made. And even if Taiwan can't do very much, that Taiwan at least has every ability to sort of, you know, pull back the covers on this dirty practice and seek some sort of recourse that way.
Another question?
Thank you, Charlotte Sieber from the Geneva Graduate Institute. I have a more basic question regarding definition of economic coercion and whether it falls or falls not within the entirely within the WTO framework. What I have troubles with is the fact that the GATT was in part built to prevent trade wars. And if we continue to think along the line of coercion and anti-coercion, it seems to me that it inevitably actually leads to a trade war. So I would like to hear your points of view, how you deal with the problem of potential escalation.
Okay, we take two more questions and we continue.
Hello, I have a question to the first speaker.
I'm curious if you have looked at the Chinese attempts to introduce similar anti-coercion instruments. In particular, I refer to anti-foreign sanctions law, which China in particular described as a instrument to self-protect itself from economic sanctions imposed against China, including against some entities like Huawei, for example. And then I have another question for Lothar. So from your presentation, I got that in your view, and it's probably the most widespread view in the literature, economic coercion not always illegal. It's illegal only when it constitutes intervention. And then the question is threshold. So this is the most kind of debated question in literature, if one would say so. And with reference to the case study, when Lithuania was sanctioned, in fact, Lithuania didn't have that much trade with China. So should we look at the trade flow when we defined economic coercion, or should we just look at the objectives pursued by this measure? Thanks.
To a brief comment and a brief question to Yuka. Indeed, I think it is a very fundamental question with regard to how do we detect intention. And I think that generally in the WTO, we have some reluctance to deal with subjective issues. I guess that you know that with regard to national treatment, there are some inconsistent decisions. But I must say that in other branches of international law, other tribunals are not afraid at all. Let's say international criminal law, intention is very important, or the ICJ, or law of the sea. I mean, in many cases, you have good evidence about the intention. And actually here, I just saw that the government of China clearly said what it is the intention. I mean, in many cases, states, they do say we intend to get something. But yeah, but it's really fundamental question. And to Liliana, what is the main defense or argument of China? Is it indeed Article 21, security, something like that? Thank you.
Take this back, okay. So who would like to respond?
Can I just briefly, because it's
Yeah,
really
please.
short. So, I haven't really seen anything official from China because they're basically denying that this is what they're doing. They're fantastic in actually using this. I mean, you have different types of economic coercion. You have explicit economic coercion, you have disguised economic coercion, and you have the silent. So theirs is really disguised. It's always about something else happening. Oh, Canadian canola is not of a good quality, so therefore we will suspend it. And suspension or the measures, restrictive measures would come like 3 days after Canada detained Huawei executive and stuff like that, right? So they never say this is why we are doing it. Of course, it's really easy to establish the intent when they say, oh yeah, that we actually want you to change your policy and this is what we want you to do. They actually don't say that. And that's the tricky part of it. And that's the tricky part of the question that Yuka has asked, because really, if you're talking about traditional coercion, you really don't talk about that intention. It is that intensity that really justifies your responsive measure. And if you look into the definition of economic coercion that is given by the regulation, which I think it's quite a brave act because there is no any definition, clear definition in international law what it is. And it's difficult in domestic law to define it, let's face it. Whoever teaches contracts or torts knows that. So the question then is that European Union in this document, in this regulation, has really put the objective measures as to how they are going to assess it. So that it has to be a high threshold, that it has to be the high intensity. If it's a complete embargo, then it's pretty clear that that is the threshold. But it never actually developed any specific reference to that intention. It just says in one particular article, oh, this is the particular measure that is aimed at interfering with other policies, and that's that subjective element. So it becomes dubious. But again, if you really read the Commission assessment, what the commission is saying, this is the last resort. This is really just for those very specific cases that do not come within the WTO umbrella, but do require our reaction. So it would be really those, I mean, how do you go about these popular boycotts that are all actually, you know, organized through China's CCP and the government organizations? And that really happened. Like Lithuanian companies were facing that. Suddenly, contracts were not renewed. Suddenly, there was no raw material that needed to be, you know, given to the Lithuanian companies. Suddenly, Lithuanian goods disappeared from the shelves, right? So that's that kind of an implied coercion that's very difficult to actually show an intention, right? So.
You would like to? Yes,
I
Lothar.
can just follow on this and say that in a case like this, of course, the question is that of the government's involvement. Yeah?
Yeah.
And we can also have questions of attribution.
Yeah.
That for international lawyers is standard. On intention, can I use maybe the categories and words which Marko Milanovic, a very pedagogically brilliant lecturer in Professor Emmanuel Redding, has used in his inaugural lecture on the subject of coercion and its international legality, which is demand, threat, harm. That's the architecture of coercion. And indeed, the demand involves the intention. But here there's some bad news that indeed certain governments do things in a veiled manner and don't publicize very clearly, black on white. You know, we had a government in the West, United States, Donald Trump, where this was far more transparent on Twitter, easy to use as evidence of what is the demand, also what is the threat. So in this other model, the threat, the harm is there, but the demand is not so officially expressed. But here's the good news, and that's where you need then evidence, and that evidence can be circumstantial and indirect, it can be intelligence. But the good news is coercion only works if the other side understands what the demand is. Because if as a country you face a trade restriction, but you don't know what the other country wants from you in order to lift that trade restriction again, or doesn't want anything from you, yeah, then it's just a protectionist measure or just a WTO breach. And then of course we're squarely just in the realm of the WTO. So if it is coercive, then you will know it, because you know there's a connection and it's a punishment for something that you have done, or a disincentive for doing it again, or for others. And so and then on threshold, again, Marko Milanovic, the zone that is a bit controversial indeed, but some of you said embargo. Well, of course it doesn't have to reach the threshold of an embargo. So the zone is that between talk and force. Yeah, force, we spoke about it, we won't get into that again. And talk is of course not coercion. If you make declarations as a government and you say, we really want, you know, that other government to do this and that for us, so that would be nice. That is of course not coercion. Yeah, but we're speaking here about economic restrictions, trade restrictions that have severe impacts. Yeah, even if it's 1% of trade, don't forget the inputs, and that this harmed Lithuanian interests in trade in all other directions. That can easily be enough. Now, the proposal, it is true that not the proposal itself, but the accompanying impact assessment report contains some language to address this question of the international law and so on. But this is not, don't understand this as an elaborate and exhaustive rationale, reasoning, and explanation. We have a consistent policy that we don't publish internal legal analysis that show whether a proposal or adopted legislation is WTO compatible. Yeah, you understand why we don't do that. Nobody else does this, by the way. So this is just small bits that we put there in order to not have nothing there. Countermeasure is indeed intended as a last resort, but it has to be a last resort also under general international law. You cannot just react to a breach by slapping a countermeasure. You have to call on the other country to cease the breach. You have to offer negotiations. you don't have to offer adjudication. Yeah? Ranjo Ruiz in the ILC pushed for that 30 years ago and did not prevail. But it is good. Adjudication is good. That's why we have 23 in the DSU. It would be ideal if that was a generally applicable rule, but it's not there. And as you know, for going to a tribunal, you need consent. So you need an international agreement to do that. That is possible. That is envisaged in our regulation, but it will depend on the agreement of the other side. Countermeasures have to be proportionate. And for that reason alone, of course, they can be challenged in court. Yeah? And that can be, again, an agreed compromise that will have to be elsewhere than WTO if this is about the coercion itself and then the legitimacy of a countermeasure. But indeed, because we have compulsory jurisdiction in the WTO, the countermeasure takes the form of a WTO departure rather than a departure from another international agreement. Bilateral, for example, the duty elimination of an FTA, then the EU cannot escape that litigation. That's why I mentioned all these things, the invocation of the right to a countermeasure before a WTO panel. But irrespective of that, that challenge is of course legitimate, because just imagine the countermeasure were disproportionate. Under general international law, countermeasures have to be proportionate. And if it is not, it's not permitted to that extent. Yeah, and to that extent, the other country should then certainly win. But if the victory is based on the mistaken application of international law, which quite a few people, one of them is sitting in front of me, have argued in the past that the WTO panel is on an obligation because of the DSU, although the DSU doesn't say that, to ignore the non-WTO justification for the measure, then of course that WTO ruling would not reflect international law, and that would be a problem that would have to be handled differently. There was a question also about Article 21. So in all standard cases, the EU in such a case would not invoke and not be able to invoke Article 21 to justify the countermeasures. Why? Because the situation is not bad enough to amount to an emergency in international relations. It's as simple as that. That does not exclude that a situation of coercion can amount to an emergency of international relations. Yeah, if it's a threat of use of force, or that gets us back to the first day, what exactly is an emergency. But the standard case of coercion, I would try to remember, does not amount to an Article 21 situation. Finally, escalation. Of course, that's a risk. That is always a risk. That is inherent in international law. That's part of the whole idea of countermeasures, because there is possibly a disagreement between the two countries. Yeah? The coercer doesn't think it is coercing. It in fact thinks that it is asking for something completely legitimate. The Lithuanian example is even a good one, because the Chinese government is of the view that it's an interference in internal Chinese affairs. To if China addresses the name of representations of a part of its territory. Yeah, that's for them an internal affair. It's also for them an internal affair if they mistreat people in Xinjiang, because for them human rights international obligations don't exist. Yeah, but that is not international law as seen everywhere else in the world, and that's why for everyone else this is not an internal Chinese affair, and therefore it is not an illegal act to impose sanctions for those human rights violations, and therefore those sanctions are not coercive. Yeah, but you can have these divergences of opinion, and then, of course, from the other perspective, the countermeasure against the coercion, which served as anti-coercion against the human rights sanction, would be permitted. And there is therefore indeed a risk of escalation always inherent in those situations. Empirically, however, we do not see escalation that never ends. Remember the China-US trade war, also Section 232. Yeah, this was more buff, and then litigation, negotiation, and not a never-ending vicious cycle of escalation. And finally, Of course, countermeasures are not the solution. They are a means to arrive at a solution, but they will not achieve that overnight.
I'd like to come back on the relationship between general public international law and WTO law, and I'd like to use an example. A country threatens to hack the infrastructure in electricity, the digital system, etc., if things are not being done in a certain way. And how would you qualify such a threat in terms of international law? Would that be something which falls under general public international law as a threat to use of force, a modern form of force? It doesn't really matter whether you shoot at a power station or whether actually you derail it by other means here. And could it also be affecting WTO law obligations? And does the rule of lex specialis somehow come into play? I wonder whether what are your views on that?
It's a very difficult question, and I don't really have an answer, but probably the hacking of the infrastructures by electronic tools could be a violation of general international law, and maybe in certain cases it could also be a violation of WTO law. But the question I have is how to respond that kind of potentially international law inconsistent conduct. And if this hacking is a violation of general international law, a response to that measure may be justified as countermeasures against the violation. But if the response measure is a trade measure, and then that measure is a violation of the WTO law, although it may be justified as countermeasures under general international law. So the response measure has like two natures to me. One is countermeasures under general international law, and then the other is WTO law violation. So
if it's a WTO violation, then we're not allowed to take countermeasure before going through the dispute resolution mechanism today, which means we basically can't react for the time being.
Well,
No, the countermeasure.
the conduct, the hacking, is a violation of international law. So the countries can respond to the conduct without having recourse to WTO-DS. It's not a matter of WTO. It's not a matter of DSU Article 23. However, so there's no violation of Article 23. However, it could be a violation of other WTO law obligations, such as, I don't know, Article 11 or Article 3. Article 3.
But if okay, let's say we take the hacker attack, and then my reaction is I stop exportation of electricity and I violate commitments which I made. So am I allowed to do this or not?
So under general international law, I think it's
I am,
allowed.
yeah. But I have a gap commitment because we basically have prohibition of quantitative restrictions, and we have even zero tariffs often on electricity. So if I stop the exportation of electricity.
So to me, so there are two assessments. One, as I said, it's justified under general international law, but it doesn't mean that it's not a violation of WTO law either. I'm not saying you can't take countermeasures against hacking or other coercive conduct. However, the response measure still has inconsistency, in my view, with WTO law.
And so I mean, if I take the measure then, because if I don't take the measure, it doesn't have any effect, and I can't really, I would just basically run the risk of a WTO violation, and then it would be up to the other party then to make a complaint to you. Is that a scenario? Because of course politically that's very difficult to make a complaint if you harass somebody and then come and say your counter action was illegal. It's Is that part of the political economy here?
But it can be the only way of getting into the WTO, because if you have a hacking incident and you want to sue the other country before an international tribunal, you have to find another international tribunal than those of the WTO, because the hacking is presumably not a WTO breach. And for that adjudication, you will need the agreement of the hacking state, which might be denied. So then you take the countermeasure, and then the initiative for the litigation is shifted.
Why would you need another forum? Because basically there's a violation. You have to. You feel this is a violation of international law, aggression, etc. So I'm entitled under Public International to react to that immediately if I want. I don't have to call upon a court to do so here.
But you can. You can, if you want to settle the disagreement otherwise and in a binding manner, then the tribunal is your option. On the breach of hacking, I mean, it's not really our subject and expertise, but we know there is the so-called Tallinn Manual number 1, which is about cyber operations that qualify as use of force or threat, and Tallinn Manual number 2, which is cyber operations that are internationally illegal, but don't reach the threshold of force or threat. And those indeed, but there can be other breaches, are often interventions. But that is then another form of intervention, but it can also be economic, of course, if it is a threat. But it's a bit different from our trade restriction, because in those cases, we wouldn't even ask the question, is this at the same time a WTO breach?
I think that Gabriel wants
Yes,
to add
we're
something.
discussing on the relationship between public international law and
Yeah,
WTO
yeah,
law
sure.
on these, and we already opened up and come in. If you like to come in right now, please do. But you need to speak into this ashtray.
But two small things. I'm not sure that hacking is not a WTO violation. There may be some intellectual property sort of violation. And I agree that the use of force, for instance, entitles you to a countermeasure. But I would also say that depending on your conception of how broad you read 21 and 20, all these countermeasures can also be justified under WTO. And then it's quite important, 28, public moral. Depending, the broader you open 28, you could almost include the entire international law.
Yeah, there was a separate session on this. I mean, this is being debated, and it's a valid debate to be had. But the more conservative view is that this is not Article 28, and especially countermeasures which which restrict trade in products that are totally unrelated.
Or 21, security, you defend yourself.
That we addressed before you enter the question whether the situation is
Really
bad enough
security. But hacking is
threshold. But can I also say two other things that are really important? Simple. One is, let's not forget about the retortion, not just speak about countermeasures, because there's also the concept of retortion, which is something you're always permitted to do. And so if that is the chosen action, our anti-corruption instrument, that is an option, then all these problems we're discussing here don't arise. And then for all of you who will, I'm sure, quite a few of you will go away from this session with this nagging question, is it really so that I can rely on a countermeasure to depart from an FTA or WTO obligation? I want to give you along with that reflection, ongoing reflection, that of course we know there are international obligations that are countermeasure proof. Yeah, I use this term, it's not well used, but you know what I mean. And which are those? Human rights obligations, anything that is used against, diplomatic immunities, at least diplomatic immunities. Yeah, but in no textbook of international law or state responsibility will you find any reference that the WTO agreement contains obligations that are of that level and quality, human rights, use programs, community, and therefore not subject to countermeasures.
Yeah. Okay, we can. I'd like to move on to another question, and going through a case where we really use the WTO mechanism. And this is a case on SPS measures. So a government has a political goal, for example, to influence the attitudes in the farming community, and then they stop the importation on apples, claiming that these apples are not safe under SPS, and the measure is being imposed. Now you have to challenge this through WTO dispute settlement. You have to provide all the evidence. It takes a lot of time, and you may not help your farmers in a reasonable period of time. So my question is the instruments we have in the WTO to address these kind of measures, are they appropriate? The traditional unilateral dispute resolution mechanism, which leaves all the rest aside, or could we contemplate collective action? Because these measures so obviously, like Lithuania, are irritant, isn't it? Everybody was irritated by this here. Isn't there a way that the international community could react more powerfully to counter these kind of measures, and therefore also frustrate the taking of these measures? Because if you take them, you pay actually quite a high price in terms of reputation. You damage your own reputation and your own credibility in international relations here. But we haven't seen these reactions. Lithuania happily is a member of the EU, so the other 21 choose in. But if it's a single country like Australia, they're just left on their own, and everybody else is just watching what's going on here. So I was wondering whether we can be more creative here, and I know that you will say this is from realpolitik is probably not possible, but I think it's still worthwhile thinking through what we could do here in such situations which are fairly clear and obvious here. Who would like to address these questions?
I think it depends on what kind of collective action to be taken. But generally speaking, if I may go back to my metaphor of painkiller and yoga, the sort of forceful strong action, strong response against like the SPS measures you mentioned could be effective, rapid and effective. And as you said, WTO-DS takes longer, but that sort of strong reaction has a lot of side effects. And actually, I'm from Japan, and Japan had an experience with China in 2010, and China banned the imports of certain rare earth, and we, together with the EU and the US, used the WTO dispute settlement, and we got violation findings, and then the China lifted the export ban, and then and then after the WTO-DS case, we reduced the dependence on China for the imports of rare earth. So it took a long time, but we resolved the problem through this kind of a multilateral rules-based reaction. So and in the previous session, we talked about not fully functioning dispute settlement. But I think I want to say that the WTO-DS is actually functioning to some extent, and we can still use this very good system. And so to me, probably maybe it's nice to be creative. It's nice to think about other options, but we should
No.
pursue
Yeah.
more multilateral reaction.
Yeah, it's not necessary instead of, you know.
Right, yeah.
I was just thinking in terms of the type of UN General Assembly resolution that, for example, in the General Council, we could adopt a resolution where a majority or even by consensus -1, the membership requests a country to withdraw these measures. And we don't use these tools at all in the WTO. I can understand that people don't want to be affected with the same type of measures and have the same damage, so they like to stay out. But there may be softer measures which have a preventive effect. That's my question.
So we have two.
Yeah, please. You need to.
Who was first, me or? Actually, reflecting on your proposal, Thomas, recently during G7 meeting in Japan, they made a declaration on a statement that they will create a special coordination platform on economic coercion. And in particular, and here I would like to quote what they want to achieve with this platform. They want to establish a warning and rapid information sharing. They want to regularly consult each other, collaboratively assess situations, explore coordinated responses, deter, and where appropriate counter economic coercion in accordance with our respective legal systems. So that was G7 meeting in Japan, where they made officially in their statement, they said that they will cooperate, at least G7 countries.
Would that be happening in the WTO or is that outside?
It will be G7, but it will be like, it will be called Coordination Platform on Economic Coercion. So probably they will send some representatives to work together.
I think that in the whole text, they are making reference to like-minded states. And it's really interesting with this one particularly, they don't make explicit reference to WTO. In the previous one, they do. And there was also a joint declaration against trade-related economic coercion and non-market policies and practices signed by Australia, Canada, Japan, New Zealand, United Kingdom, and United States, right? In June last month as well. Again, one club kind of a solution.
But Thomas, you asked about the WTO, and of course, WTO is a relevant.
But what about the microphone?
This is the microphone. This is my.
Yes, but he is speaking.
Yeah,
No,
okay,
no, he does not need. No, no, he doesn't
I'll
need.
manage.
He does not need, okay.
He has it.
No, if he speaks, he needs it. Otherwise, I'll give it back to you, right? Just a second. Don't worry.
The WTO is, of course, a relevant forum, and you, Thomas, you are asking about WTO bodies, committees, and so on. Yeah, there is certainly a potential there, and it's being used. Council for Trade and Goods has every meeting several coercive measures on its agenda, and the coercive aspect is raised by some in those committees. The direct victim sometimes prefer to confine the statements and criticism to the WTO problem, the SPS illegality or the anti-dumping illegality. And as you know, a committee can hear many statements, and then that's it until the next meeting. Dispute settlement is an option, and so far, WTO action is the only action that has been employed. Canada brought the canola case, Australia wine and barley anti-dumping cases. The EU brought the case against China for the Lithuania restrictions. So that is always an option. When disputes are ongoing, then they move out of the committees traditionally. Australia has now a settlement over barley, which is in implementation. Part of such a settlement is often that the coercive measure is withdrawn, and then we are speaking about 3 years down the line before a panel ruling comes out, and then no panel ruling comes out. So that means the reputational cost is then avoided, and that could also play
a role. Yes, yeah. Okay, Maria.
It was just to see whether I understood all the important contributions that have been proposed to us, because I do think that in the anti-coercion instrument, there is an answer to the suggestion of Professor Cottier beyond the very important initiative that was recalled by Irina. because it says that before adopting a countermeasure, the European Union will have to gather together the countries that are potentially interested in joining the European Union in facing the situation that is qualified as economic coercion. So there is this multilateral or plurilateral diplomatic initiative. But then if I understand correctly the reconstruction of the legal framework by Lothar, basically you are saying, correct me whether I misunderstand you, that in case there is an infringement of the principle of non-interference in internal or external affairs, even if a measure adopted by a WTO member has trade effects, these trade effects should not be considered as falling within the WTO system. Are you saying this? No. Okay.
So in the disputes, I just mentioned proof. Otherwise, it has been said correctly that WTO litigation is an option that's even mentioned in the draft anti-coercion instrument. Now, the question is that an effective option? If you litigate during the litigation, the measure stays there. And what you said earlier, Thomas, I think you were also alluding to faster remedies. And then we have the duration of WTO dispute settlement, the absence of interim measures, the absence of damages for past harm and injury, all things that exist under general international law, and that reduce significantly the price for the wrongdoer. Yeah? But I don't think we need to discuss here the challenges that would be involved in trying to make WTO dispute settlements go fast, to add interim measures that the coercion country has to suspend its measures during the litigation. That would be really good. In the WTO, traditionally, we always say, no, we can't do that. If we have a measure to protect the environment or health, we cannot suspend it until we hear whether that is permitted under WTO agreement. But for a coercive measure, that is perhaps far more feasible. And under international law, countermeasures have to be suspended during litigation, but only if the challenge measure is also suspended.
I think the idea of interim measure is something which is really interesting to reflect. You know, it doesn't really prejudge, because you could link it up with damages in case the measure is not correct. But these are just things one could contemplate also for other cases too. Okay, so we'll have 8 more minutes. So let's take final questions, and then you have your final word.
Countries see their obligations both under the WTO agreement and under other international agreements and coherent agreements. I'm wondering how good it is for that to cast to supply an answer that perhaps we need to think about. Perhaps we are already thinking about that in terms of what Lothar has said, because The response in most of these situations is just been a WTO response. And so they're going sort of the least, or the sort of the narrowest road possible in order to maintain some sense of coherence with international law, not rejecting
That would, I mean, that would require that the WTO is actually allowed to look into international law generally independently from WTO law. If we use the use of force public international law avenue, that we would link this up.
Further questions? Yes.
Yes, Patrick Abel, University of Passau. I have a question that relates to the bigger picture, let's say, because Ting Chen has also mentioned other responses to coercive measures, such as, for example, building up or strengthening the general resilience of a country, of an economy. And I think the EU has introduced lots of instruments in the last months and years that are precisely oriented towards that, building up, for example, obligatory supplies, for example, solidarity mechanisms in situations of economic emergencies. And I would like to ask, well, Lothar, actually, if that is something that is thought together and how it influences, especially the proportionality analysis of potential countermeasures. And I'm wondering if resilience building is so strong and at some point that the room for countermeasures is reduced because there are other means available to react.
I'll put it here.
Greg, did you want to say something? No, this was not your
comment.
Who wants to?
The question was to you.
Yeah, but not only. There were several remarks. But I can kick this off, and then anyone please jump in anytime. So yes, of course, there are many other things that can be done: mitigation, alternative destinations for the exports that are blocked. I have here focused more narrowly on the legal questions and the international law and WTO law legal question. That is fascinating enough. But of course, this field is much, much broader. Has been well studied, by the way, everything the Australians did, the Canadians also for canola, but the Australians were under severe pressure. This was it was 5% of all Australian exports. So that's well researched, well documented inter alia by the Australian Strategic Policy Institute and the Center for Strategic Initiatives, CSIS in Washington. CSIS in Washington also has held two events. One was the launch of a report on coercion, at which the State Department spoke and presented in an impressive manner all the things which the United States did to help the Lithuanian economy, with the result that the Lithuanian exports, rather than falling as a result of all these measures, increased by 39%, maybe also due to the other factors. But so a lot can be done. Compensating the victims is also an option for us. That is an option in this instrument only if we obtain reparations, which is also a consequence of a breach of international law. That doesn't exist at all in the WTO, and I know that also elsewhere in international law that is not always realistic, but it does exist, and not only in investment law. So that is, of course, a much more complex picture. Definition of coercion, no. So if you look at Article 2 of the proposal, and you look at Article 2 of the finally adopted regulation in the fall, you will see that this aims to match exactly coercion under international law. There is, of course, also the requirement of a measure restricting or affecting trade or investment. That is for us to not capture any coercion, but only economic coercion. That was also a reason of competence for us. But the demand having to be relating to an area falling under the sovereignty of the target, you will find that language there very expressly.
Very good.
Can I just also refer to the US law, because that has not been spoken much about. US legislation, which is a bill, is fascinating for one reason, namely that it does not apply to cases where the United States is coerced. It applies only to cases where someone else is being coerced. And for such situations, the bill inter alia provides for the possibility of punitive duties against the coercer and preferential duty reductions for the victim of coercion. So I ask all of you how that is going to be justified under the WTO agreement. It's a completely different story than the one I told you, because countermeasure is only for the victim. We have collective countermeasures, but only in the event of erga omnes breaches. The use of force is an erga omnes breach. Human rights violations is an erga omnes breach, but interference in the internal affairs of another state is not an erga omnes breach. And perhaps a final small remark, because the term coercion is, of course, per se much broader than what we discussed here today in relation to non-intervention. Coercion per se, even in law, covers everything where force is being used. If a criminal is arrested by the police, that is coercion. But that's, of course, not what we're speaking about. And the term is also misused sometimes to say that was a direct reaction to the G7 statement, by the way, the day after Russian government, the Chinese government, but also academics everywhere in the world said, oh, but the G7 or the US government, the EU are the biggest coercers in the world, because look, they impose sanctions now against Russia, tons of sanctions, that is coercive. And so it always brings us back to the definition of what exactly are we speaking about? Is it the intervention? And of course, a sanction, which is also a countermeasure in response to the use of force, is of course not interference in internal affairs, because the use of force is not an internal affair.
Yeah. Okay. So I think we're done, and I'd just like to offer the possibility to have a final remark, the three ladies.
Yeah, if I can just say something that would be also response to the question. I think that what we discuss here about the European Union approach is really that, this regulation may be just one pill, but there is a treatment that's much broader to actually build the resilience of the system through a number of other regulations. Some are new, some are reformed, like the trade enforcement, FDI screening, foreign subsidy, like 90% of investments that are coming from China have some sort of subsidy. So better screening as well, more support for domestic industries. That could be debatable to what extent that itself can be against WTO rules. But anyways, there is a whole system that's been put in place within the EU. And I think that people should really think whether anyone else can go that route. But that's the route of actually minimizing that asymmetric interdependence, right? Building the resilience within the system, trying to make it stronger, better monitoring, more transparency, and so on and so forth, changing the blocking statutes so that maybe individual companies can actually get some concrete remedies as well, because that one was really capturing only particular extraterritorial sanctions of the United States, reach of US law. So whether other countries could do that, I'm not quite sure. I think that European Union is doing the stuff that maybe developed economies can do, but for small countries, I really doubt that they can just rise to the occasion.
Jim, would you like to have a closing word?
I think for everyone for a lot of questions for me. I'll bring them back and to improve my study.
Very good. So you got some feedback. Okay.
Well, very briefly, this raises a very interesting question of the relationship between WTO law and general international law, or where WTO law sits in general international law. And as someone suggested, the principle of systemic integration requires WTO law to be interpreted harmoniously with other areas of international law. However, at the same time, I think international law is inherently fragmented. So we can't have hierarchical, integrated, systemic law, like domestic law in international law. So, well, this is a very fascinating question, and I think I'm gonna keep studying on the subject.
So thank you very much. I'd like to thank the panelists for their contribution, the comments, and also your remarks and contributions in this interesting topic. And I'd like to close the session. Thank you very much.
It's interesting.
Any relevant to you? Yeah, did you get any